I'm Rick Kaler. Thanks for joining me. Can a financial advisor represent your best interests and still earn a commission? You might be surprised to learn that this can sometimes be the case. It's really up to you to find out. Being required to put the consumer's interest first, which means representing a client rather than selling products and services to a customer, is called having a fiduciary duty. While fee-only planners are inherently fiduciaries, they don't exclusively own the fiduciary domain. The definition of a fiduciary doesn't inherently ban receiving commissions. Numerous statutes and applications of common law can require someone receiving a commission from selling a financial product to act in a fiduciary capacity. One such circumstance was discussed in a blog post at kitsis.com by Dwayne Thompson, who's president of Potomac Strategies, LLC. It's a legislative and public relations consulting firm. Those registered with the SEC as a registered investment advisor, which commonly is referred to as an RIA, under the Investment Advisors Act of 1940, are required to uphold a fiduciary standard of care. Advisors must register as an RIA if they, and I'm going to quote the Act, for compensation engage in the business of advising others, end quote. And that would be advising them about investing in securities as a central part of their business. The 1940 Act has almost nothing to say about linking compensation to fiduciary responsibility. While large firms selling financial products can argue whether they must register as RIAs, it is clear that anyone who is registered as an RIA is held to a fiduciary standard regardless of their compensation structure. That said, the chances are an advisor who is compensated 100% by commissions is not an RIA and not held to a fiduciary standard. Of the 11,475 advisor firms registered with the SEC, only 4 are commission only, and that's according to Thompson. Of the remainder, those that receive commissions also charge some type of fee. The overwhelming odds are that if you don't pay a fee to a company giving investment advice or selling a financial product, they are not legally required to look after your best interest. Even though an RIA who is totally or in part compensated by commissions has a legal obligation to put your interests first, they may still have a conflict of interest, which the SEC requires them to disclose. The size of that conflict depends on the percentage of an advisor's revenue derived from selling financial products. So let me give you an example. An RIA receiving 90% of their revenue from the sale of financial products in the form of commissions, I would suggest has a large conflict of interest. The sustainability of the company and advisors' careers depend upon the sale of financial products. Arguably, it's going to be very difficult for an advisor to remain unbiased, especially if what may be in the client's best interest is a no-load, low-cost index mutual fund or variable annuity that doesn't pay a commission. Conversely, an advisor receiving 99% of their revenue from fees and 1% from commissions on the sale of, let's say, low-cost term insurance has almost no conflict. The sale of the insurance is most likely a convenience for clients and has an insignificant financial impact to the advisor. Now, in order to find out the likelihood of advisors upholding a fiduciary standard, first ask whether they are an RIA with the SEC. If not, they owe you no fiduciary responsibility. You're a customer. If an advisor is an RIA, however, don't assume that there's no conflict of interest that may taint the fiduciary relationship. Ask how much of the firm's gross revenue comes from commissions on the sale of financial products, and how much comes from fees paid directly by clients. The higher the percentage of revenue that comes from fees, the lower the potential conflict of interest, and the greater the chance that you'll receive unbiased, client-centered advice. Thanks for joining me.